Constitutional morality is not a natural sentiment. It has to be cultivated, said B.R. Ambedkar. Good afternoon to everyone. This is Ardra S. Shubhu, Commissioner, Student Ethics and Constitution Commission, IIT Madras. I'm very delighted and honored to share with you all that. We have with us Dr. Sudhir Krishnswamy, Vice-Chancellor, National Law School of India University, as the esteemed guest speaker for the second lecture of our webinar series titled Voices of the State, who would talk to us about the theme, Building a Constitutional Culture. On behalf of IIT Madras and SECC, I extend my hearty welcome to you, sir. Now, I would like to welcome our beloved faculty advisor, Professor Anup Kumar Bhandari, to the event, and we also kindly request you to deliver the welcome speech.
Thank you, Ardra. Am I audible?
Yes, sir, you're audible.
Okay. Good afternoon, everyone. Honorable Chief Guest, dear colleagues, and my beloved student. On behalf of the organizers, me, Dr. Anup, Faculty Advisor of Student Ethics and Constitution Commission, SECC, and Student Legislative Council, SLC, of IIT Madras, and the entire IIT Madras community, I feel extremely honored to welcome our esteemed guest today, Professor Sudhir Krishnswamy. I wish you a warm welcome, sir. Being the regulatory body of the student governance at IIT Madras, SECC is responsible for enforcing the students' constitution and conducting institute and hostel level elections. We take pride in continuing our lecture series, Voices of the State, in which we provide a platform for highly accomplished speakers to interact with us and inspire the IIT Madras community. It is with boundless pleasure and honor I announce that Professor Sudhir Krishnswamy has kindly accepted our invitation to deliver his talk today. To introduce him briefly, Professor Krishnaswamy is currently the Vice-Chancellor of the National Law School of India University, NLSIU, Bangalore, and the Director of the same university, Distance Education Department of the same university since 2019. He is also the co-founder and trustee of the not-for-profit research trust, Center for Law and Policy Research. An alumnus of NLSIU, Oxford University, and also a Rhodes Scholar, he has earlier worked with the Prime Minister's Committee on the Infrastructure Planning Commission and the Kasturirangan Expert Committee on Bangalore Governance. He is also the author of Democracy and Constitution in India, a study of the basic structure doctrine, published by the Oxford University Press. On behalf of the SECC and the entire IIT Madras community, I extend my wholehearted welcome to you, sir. As curious IITians and citizens of the country with the longest written constitution in the world, we all are honored and privileged to learn how constitutional culture is built in a society from none other than you, sir. I hope that you would also enjoy your interaction with us. Over to you, sir.
Thank you very much. May I just confirm first and foremost that I can be heard and seen? Yes?
Yes, sir, you're audible and you're clearly visible.
Thank you so much. So thank you, Dr. Anup Bhandari, for the warm introduction and welcome. Ardra for helping us set up this afternoon, and the members of the SECC for inviting me. It's a pleasure to be at the interacting with the IIT Madras community. I wish sooner than later we'll do it in person, but today let's see how we can think about and think through what it means to build a constitutional culture in India. I'm going to take, and we've discussed, I've got about 19 slides. I think I'll take about 20 to 25 minutes to just work through some grounding ideas on what it would take to build a constitutional culture. This is not either commonly understood or the subject of our school civics education, though we learn about the Constitution. We learn about it so passively that we sometimes just fail to connect how it might matter to our everyday lives. So the focus of my talk is going to be about how can we engage with our Constitution in everyday life? What kind of difference can it make? And I will try to display that by concrete example. So if I can move to the next slide, I think that we begin often by asking, what is the place of the Constitution in our everyday life? Do we need a constitution, and so on? If I can just request our colleague to just move the slide along, please. Yeah, we usually, it's a good place to begin by asking, what is the place of a constitution in our lives? Why do we even need one? And to then ask a little more, in a more focused manner, how did we get around to making a constitution? That's not a foregone conclusion. The medieval history of India will confirm that we were not constitutionalists, by culture, by civilization. These are new ideas. How did we come to it? And then I'm going to focus on the Maratha 2021 case. And I'm going to try and use that case as a foil to have us think about two different questions. How do we think about constitutional history? Why should we know it? And then how do we think about constitutional interpretation? And my purpose of taking the case and to address this question is not didactic. I don't think I'm here to teach you what the position should be. I'm here to try and have you engage with how you would think about a position on these very important questions. What kind of resources would you use? What methods would you use? So that's what I'm going to focus on. And then hopefully in the discussion and conversation, we will get the opportunity to puzzle out a little more about the case itself and the place of the Constitution in deciding a case like this. Let's move on to the next slide. So the first question that I want to address, and I want to use a sort of cryptic slide. For those of you who are cricket fans, you might recognize that Ben Stokes in the picture puts his hands up because he dives in to make sure that he doesn't get run out. The ball runs off his bat and gets all the way to the boundary. And the question that is posed is a not so common occurrence in cricket, but a complicated one. And it's complicated because there is no rule in the cricket book that tells you what happens if the ball runs off the bat in the context of an overthrow. And as his expression shows you, puts his hands up and says, I don't know, the ball's run off to the boundary, do what you want. So there are many questions in context, like a tightly bound, rule-bound game that escape rules of narrow definition. And often, what do we do? So when you say that, okay, I didn't do anything here, it might be a boundary, it might not be a boundary. How do you settle questions like these? Let's move on. And the general recourse, if I can just move the slide, please. Yeah. Generally, what happens when we are players of a common game and we disagree about an outcome is that we adopt a decision rule. We just say that, look, in context like this, I will give the decision to some person, or I will give that decision to some institution. Not because necessarily that institution has some divine expertise, but given that there are parties who disagree about what an outcome should be, you leave it to a third party to mediate that dispute. And in social settings, all kinds of social settings, we get very complicated reasons to disagree in a social setting. So you have two options in those kinds of contexts. You either settle it by the power of the weapons that you wield, or you settle it by some form of civic decision-making. And the place of a constitution in a society is to really answer the question, who decides? Right? And constitutions can be of various types, but you need some view on the question about who decides complicated disputes. Let's move on. In a simple game, what we would do is that we would put an umpire in place, and so Kumar Dharmasena in the picture gets to decide whether it's 2 runs or it's 6 runs, and he says it's 6 runs. I give the 4 that goes off the bat, and I give the 2 that you run. Now, not everyone might be happy with the decision. Clearly, there are 11 players on the field who wouldn't want to concede those 4 runs. The batsman might be happy. But then what happens in a case like this is not that we get a perfect decision, but we get a decision by an umpire that we have already agreed at the start of the game that this umpire gets to decide, right? And once we have made this decision rule, we just live with it. And Kumar Dharmasena can get some decisions wrong, may get some decisions right. We hope that he gets more decisions right than wrong. But once we confer that question, who decides upon the umpire, we don't go back on that. We settle the rules of the game in this way. Let's move on. And this entire set of rules is captured in the rule book. Right? In the case of the game of cricket, the laws of cricket are prescribed by the MCC, and there is an official document. So if you have a doubt, you can work your way through the pages, pick your appropriate rule that applies. There might be a dispute between parties about which rule must apply, but at least you have a rule book. So you have a rule book, you have an umpire, and life can go on. And this resolves a huge coordination problem. Otherwise, given that we have different interests, I want it to be 2 runs, you want it to be 6 runs, there is no other reasonable way of settling disputes of this sort unless we just leave it to the power of our arms, or we devise a model like this where we adopt some common laws and then we confer decision-making power on an umpire. This is what we do in the game of cricket, but this is what we do in social and political life as well. So let's move on. In social and political life, we adopt a rule book that we call the Constitution of India, adopted first in 1950. And what does this constitution do? It sets out the basic principles and norms. It says that our social and political life is going to be organized like this. And we're going to have these 3-4 institutions that define our relationship to each other and to the institutions. So you have the legislature, the executive, and the judiciary, given very discrete roles. And you know that these roles are a part of your civics education, so I don't need to go into this. But the legislature gets to make laws, the executive gets to make some minor laws and gets to implement these laws. And the judiciary, which is kept separate from the legislature and the executive, gets to implement these laws. And then there are complex relationships. There's a relationship between the center and the state. There's a relationship between the state, and I must say that the state here, S should be small capital. I mean, generically the state, whether it is a local government, a provincial government, or the federal government, they all make up the state. We have to clarify the relationship between these political institutions and the citizen. And then we have to clarify the relationship between citizens and citizens, right? How do we relate to each other? What rights and obligations do we owe each other? So this is the kind of setup that the Constitution creates. And it's with this setup that we think that at least the humdrum issues of daily life has a coordination formula. With this coordination formula, we at least shouldn't have to resort to open violence on the most basic questions of our everyday life. If there is a policeman who issues you a parking ticket, then you don't have to lose your shirt about it. You understand that the policeman is authorized by the state and by laws to give you that ticket. You may think it's unfair and that you were just there for 2 minutes or whatever, but you take it on your chin and you move on. You say, okay, there is some rule framework. But if every question of a parking ticket is to be negotiated by the strength of your power, whether that be social or economic power, and the strength of the enforcement officer's power, then we would live in a rather ugly place. And constitutions put in place these civic arrangements to help us solve these basic coordination problems. Let's move on. The place of, and to analogize from the question of the umpire in cricket, we confer the ultimate decision-making power on the Supreme Court. And we say that no matter what the legislature thinks, no matter what the executive thinks, no matter what individual citizens think, we are all bound to accept what the Supreme Court decides is the proper interpretation of a particular rule of the Constitution. Now, we do think that Supreme Court judges are experts at what they do, but even if they're not always the biggest experts in their field, the rules of the game are that you live with it. Right? They are the people who are given this authority, and we are willing to confer that authority on them to make this call. All the line calls are left to the Supreme Court. So this is the kind, I analogize to a game today because I think it's very useful to think about law, the rules of sport and the rules of law. They are so closely similar, and they solve such similar problems that it's a powerful analogy that we can use to understand the place of the Constitution in our everyday life. Let's move on. So the next question that I want to address is who gave us this Constitution? Right? So yes, we know that there are some rules of the game. We think it solves most of our coordination problems, but why should I accept it? Somebody made these rules. What do I make? Why? Is there some good reason that I should accept these rules? And to this, I think there can only be a historical and political answer. To the question, why should I accept it, or I can come up with better rules, that might be a fair assumption. But in the context of large, diverse political societies, the critical question of constitutional creation is one of common consent. It doesn't really matter how brilliant you might be. What matters is the fact that a common consensus is built around a constitutional arrangement. And in this case, the Indian Constitution was created through a very elaborate process where a constituent assembly was put together between the periods 1947 and 1950. It had a good number of members, about 389. They were not directly elected, and they were not elected by a universal adult franchise. They were elected indirectly. But at the time that the Constituent Assembly was put together, there was no more democratic chamber in this country, right? So we also understand, as we should, that we, as a country, we're new to democracy. We're only 70 years old. It's not like we've done this for centuries. We've come new to these questions, and the Constituent Assembly was the most democratic assembly that had ever been created in subcontinental history when it was created in 1946. Not perfectly democratic or representative, but substantially so. What is also important to recognize is that the Constituent Assembly had very elaborate discussion and debate over the details of the Indian Constitution. Across 166 sittings, they went over all of these clauses, voted on individual clauses, and adopted the Constitution altogether in consensus. It went through 3 drafts and a rather intense deliberative process, certainly a lot more deliberative than anything that we do at the moment. If you look at how legislation is passed today, the quality and time of deliberation is far more limited and constricted than anything that you see in the Constituent Assembly. Let's move on. And to the question, how do you know this? You can look at the Constituent Assembly debates in great detail, and I would recommend a small video that we made as a part of the Center for Law and Policy Research, which describes in a matter of just 2 minutes how you can think about what the outcome of that Constituent Assembly process was, which is that we gave ourselves a constitution that was a dramatic departure from the past, both the political past and the social past of the country that we now know as the Republic of India. I'm not going to show you this video. I just highly encourage you to take a look at it. I said it's under 3 minutes long, 2+ minutes. And I suspect that for those of you who are interested in the topic, this will be let me just say that it's nothing like what you've seen before, and entice you to try and take a look. Let's move on. So we gave ourselves this constitution. It was a radical document. It was radical both politically because it adopted universal adult franchise. It was radical socially because it put in place an agenda of radical social transformation into the constitution. At that point in time in 1950, the Indian constitution was different because not many constitutions did this. The Indian constitution makers were both bold enough to put that agenda into the constitution. And now I want to pivot to talk about one case for the next 7 to 8 minutes that will give you the ability to think about both the Constituent Assembly debates and its contemporary interpretation in what I think is an interesting way. So in 2021, as most of you would know, the papers have been inundated with a discussion about the Maratha Reservation case. Now, the Maratha Reservation case is deals with an attempt by the state government of Maharashtra to create a separate quota for the Maratha community. The Maratha community is a politically dominant community, but not a socially most forward community. So it's a community that enjoys political power, enjoys some economic power, but is not socially forward within the structures of the Indian caste system. So the argument that was made by the Maharashtra government is that the category other backward classes should be expanded to make a special quota available for the Maratha community. But by doing this, the 50% threshold on reservation quotas generally was breached, and surprise, it ended up in court, and the courts have been battling with this question for some time. There are many issues in the Maratha reservation case, including why is the Maratha community to be considered backward and so on and so forth. But I'm going to deal with just one issue. Should reservation be limited to 50%? Can it go further than 50%? If so, why so? What does the Constitution say about it? What does the Supreme Court say about it? And so on. And I'll give you a sense of how we face difficult political and social problems, which are relatively peacefully negotiated through constitutional argument and through constitutional means. Let's move on. So in the Maratha reservation case, I'll just wait for this. Yeah. So the key provision that we are talking about in the Maratha reservation case is Article 16.1 and Article 16.4. And now, I don't know how many of you have been force-fed constitutional text, but I'll take you through these two small provisions in a small way. The Article 16.1 tells us that in public employment, there should be an equality of opportunity for all citizens. What do we mean by that? We usually mean, and I'm going to metaphorically respond to this, that we all have a place at the same starting line. Right? So if we are running a race, we are all at the same starting line, and that is equality of opportunity. Then who gets the position is left to individual selection, but we at least start at the same line. But Article 16, Clause 4 changes or modulates this concept of equality of opportunity by allowing for reservation of appointments for the backward classes, so long as they're not adequately represented in the services of the state. Now, each of these phrases matters, right? So it's a provision for reservation. We understand, I don't think I need to explain what reservations are, but they are a particular kind of affirmative action where you set aside some seats in a separate quota. So it's a quota-based model of representation. The second is who is a backward class of citizens, who gets to decide, right? So, and the third is that you must not be adequately represented. Now, what is adequate representation? Is adequate representation proportional representation, or is adequate representation just reasonable representation? That is, broadly, we should have a mosaic of people in public employment. It doesn't have to mirror the population of the state or of the country. These are questions. Now, I promised you at the start of the slide deck that the Constitution settles questions. But here are questions that the Constitution partially settles. The Constitution says you must have equality of opportunity and you must have adequate representation. Now, you have two principles. How do you square off these two principles? How much of equality of opportunity, how much of adequate representation? That is not determined by the text of the Constitution itself. So where would we go? Inevitably, you'll have cases, and the cases will go to the court. So let's go to the next slide. So when cases go to court, what do courts do? Courts have to interpret the Constitution. How will they interpret the Constitution? They can interpret the text, but usually what they do is they will take a turn to constitutional history, right? And the constitutional history of Article 16 reveals a rather rich debate. And I'm just sharing two small snippets of the debate. The debates are available. The Constitution of India.net website, which I work on very closely, provides an easy access to these debates. But let me just highlight two participants in this debate. Both, one of whom is from the state of Tamil Nadu, T.T. Krishnamachari, and he took the view that what should this backward and forward be? And his view was that it should be a literacy measure. But if you adopted literacy in 1950, literacy was less than 20%. So he said, okay, 80% of people are backward. We can give them this kind of reservation. Now you can understand from the T.T. Krishnamachari reference that he is suggesting that literacy substitutes for caste, right? That we should have a literacy test, not a caste test. Ambedkar, on the other hand, takes a different view. And we know enough about the political history of India to know that T.T. Krishnamachari and B.R. Ambedkar are two very different people from two very different social constituencies. What does Ambedkar think? Ambedkar seems to think that ultimately reservation has to be a minority, or has to be to a minority of seats. So in a sense, he anticipates the 50% principle, because he says that's the only way that the first principle, the equality of opportunity, can be reconciled with adequate representation. So he seems to say that 50% and below seems to be a good thing. That's the way we can reconcile it. But he's very clear that reservation is a demand of particular backward communities. And when he uses that expression, backward communities, he means backward castes, right? So he's very clear about that. So notice the divergences and the convergences here. The members diverge on the question of who can be a backward class. They converge on the question roughly that, okay, it can be 50%. You know, this idea that we have a 50% limit may not be a bad idea, both for Krishnamachari and for Ambedkar. Let's move on. So, surprise, surprise, this gets into court, and the courts have very different views. In the early cases in 1962, the court takes the view in a early case called M.R. Balaji that it should generally be below 50%. And they echo Ambedkar in this, right? They say even Ambedkar said 50% limit should be adopted. As we move across historical time, and I'm not going to take you through every detail, by about 1975, about 13 years later, in an important case called N.M. Thomas, 2 out of 5 judges start to doubt the 50% limit. Say, maybe not 50%. In some cases, we might have to give 60% or 65%. And then this goes all the way, and I'm going to jump to 1992, In the Indira Sawhney case, the courts expressed very many views. 9 judges, 3 seem to think that the 50% limit is an absolute limit. 5 seem to think that it is a limit, but exceptions can be created. And that's how the debate progresses. Let's move on, and I'll speed up at this point. We'll go to, yeah. So now this case is back in court, and the case is back in court in the Maratha reservations case. And the arguments go something like this. The people who think that the 50% limit must be binding point out that in the Indira Sawhney case, the 50% limit, at least 8 judges seem to endorse it. And they also seem to think, as Ambedkar did, that you need to strike a balance between the equality of opportunity and affirmative action. Those who argue against it suggest that, look at the actual numbers of people. The numbers of people who make up the backward classes are more than 70% of the population, if not even more than that. So the 50% limit does not make sense. So just notice the complexity of what's going on here. There's a debate when the Constitution is drafted. Then the Constitution is drafted. Then the courts interpret the constitutional text. They put in place a 50% limit. Now there is a debate in court again about whether that 50% limit should be sacrosanct or should be subject to exceptions. And if we create exceptions, how we create exceptions. I want to just drive home the point of complexity. Notice that nowhere in my presentation so far am I suggesting that the world is made up of good people and the world is made up of bad people. Good people argue for breaking the 50% limit. Bad people argue for the 50% limit. No, that's not the way to think about complex social arrangements which constitutions are meant to resolve. I present these matters as if they were all reasonable people who have different views about what outcomes must take place here. Let's move on. Yeah, and so then what we do is we get a decision. The court takes the view that the 50% limit applies. And the 50% limit is a considered position that a clear majority of judges in Indira Sawhney adopted, and hence anything that the Maratha reservation that crosses 50% will not hold the field. They also take the view that whatever the argument may be about social circumstances, the social circumstances are not so dramatic that the rule must be abandoned in a case like this. Now notice I put up the judges' photographs not because I seek to point out what each of them said or who got it right or who got it wrong, but if you just scratch a little beneath the surface and understand the social backgrounds of all these judges, you will understand that they come from the widest social, religious, and economic backgrounds, linguistic backgrounds that you can imagine. And this is the magic of collective decision making, right? Put people together. Yes, they're well trained. They're qualified to make these decisions. We may like some decisions. We may not like some decisions. But the point is that they arrive at those decisions in an expressly rational way. They give us the opportunity to critically engage. Right? And then if we are fervent believers that 50% limit must go away, we have an opportunity to argue against it. And this is what critical engagement allows. But notice that the point of this critical engagement is the absence of violence. Right? That is the key to constitutional arrangements. Let's move on. So what I tried to demonstrate to you on an issue, a contemporary issue that is alive and engages our newspapers and engages common citizens in complex ways. I know that in Tamil Nadu, the NEET question is extremely extremely volatile, and exercises both students and politicians alike. But how do we think about complex social and political problems like this? Now we can say we'll just think about it in any broad way, and whatever happens happens. But the genius of the 1950 Constitution is that it allows us a framework to think about these complex social problems and eschew violence, because we may disagree about outcomes. When we engage the Constitution, what really helps us is to engage the history of the constitutional choices being made. Constitutional choices were made. They were made by a group of people. They're human decisions. They were made in the best understanding of what was India at that point in time. It does not settle all issues. It is foolish for anyone to pretend like, however well a constitution is written, that it settles all the issues of all times. No, it provides a framework for settlement. And in that design, the Indian Constitution is remarkably stable. It provides a well-distributed power architecture that allows a framework for peaceful settlement. And understanding what choices were made historically in India, and then understanding the framework for settlement, allows us to move forward as a peaceful society. The second thing is that whenever any issue, we disagree about a lot of issues. We are a loud democracy and a noisy democracy. But whenever we disagree with an issue, particularly, it invariably ends up in the Supreme Court. When it ends up in the Supreme Court, parties get to argue, they get to present their views. Now, increasingly, they present their views on media as much as they present their views in court. And then ultimately, through that deliberative open argument process, we get a particular constitutional outcome. People may not like those constitutional outcomes. They can wait till the next case and represent their case. Nothing is lost, right? Everyone gets the opportunity to come back to court on the next occasion. Provisionally, the 50% rule in the Maratha reservation case holds. That's how it works. That's how a constitutional democracy works. It's a chain novel. People are writing chapter after chapter. You have to make sense of and understand what chapter are we on, and where do you think this story must go, and engage with that process. Next slide, please. So this process of constitutional engagement is what makes for a successful constitutional democracy. Now, many people look at the Indian Constitution and point out some particular substantive feature. They'll say, "Oh, it's too long," or people might say, "Oh, it gives too much power to minorities," or people might say that, "Look, it gives a very fair distribution of material resources," and so on and so forth. So there are substantive things that the Constitution settles. But constitutions don't settle just because they write brilliant rules. Constitutions survive in a society based on the ability of the citizens of that society to take that constitution seriously. What does it mean to take a constitution seriously? Taking the constitution seriously doesn't mean blind faith. It doesn't mean that we take the position that the constitution is perfect. It's the solution and the answer to everything. Now we can just sit back in our chairs and follow the constitution. It doesn't work like that, because constitutions don't settle questions unambiguously. You have to interpret constitutional provisions and apply them to particular cases. So the only thing we can hope to do is to cultivate a critical constitutional culture. The first step of a critical constitutional culture is that we must say to ourselves, okay, this constitution has worked for 70 years. It's kept us from becoming, Ethiopia as it is today in the midst of a civil war. India is not Syria as it was for the last 7 years in having, riven with bloody conflict. And we are not Iraq. And there are good reasons to know that why we are not these countries. And that is not blind faith. that is an understanding that some critical good choices were made in the period 1947-1950. It's kept the peace. There's no guarantee that the peace, that we are somehow a very peaceful people, and then we will always be peaceful. We can only go down that path if we engage this constitutional culture. And I just throw in this line that we understand that ultimately we're a creedal nation. What is a creedal nation? A creedal nation is one that appreciates that people are very different socially, our genders, our classes, our castes. We're very different people. But what we can share is we can share a subset of common political values, constitutional values. We say this much we share. Everything else we may be different about. But if we can create a critical constitutional culture that allows this shared common values, we're well on the way to sustaining a constitutional arrangement. This is not easy. Not many countries achieve this in our current times. And for a poorer developing country like India, the effort has to be far more serious and intense to get there. And let me go to my last slide. And the only way that this kind of constitutional culture gets built is by this constant ability to look forward and to look back. When we look forward into the issues of our day, very often we find that these issues are in the Supreme Court. So we must understand what is our court doing, how is it interpreting and responding to the issues of our day. We must engage the court. When I say engage, I don't mean praise, I mean critically engage. Sometimes the court gets it right, sometimes it doesn't. And as citizens of this country, we must hold the court to account. Second, we must always have the ability to look back. A creedal culture, a constitutional culture is built by this ability to understand the past. Why were the choices that were made made? And these choices were made across 100 years, you see, of the freedom movement. It is the period 1850 to 1950 that creates the Constitution of India 1950. It's not the product of 2 years or of 3 years. It's 100 years of work by various people that goes to create that Constitution. This ability to constantly move forward and move back is what all of us as critical citizens need to have the ability to do. I don't think that the Constitution is safe if you leave it to the lawyers. Right? You can't just leave it to the lawyers and the judges to maintain this constitutional culture. It will be all of us and all of you as bright young students in the best institutions of the country to make that engagement possible. And that's the motivation for me to be here with you today. So let me stop there and pass it back to you, Andra. Yeah, we can get rid of the screen as well, share screen. Thank you.
Thank you very much, sir. It was a very remarkable and concise talk. Now, I guess we can have some questions. So I request the audience, if you have any questions, please feel free to type in the chat box. We have received some questions beforehand itself. Maybe we can start with some of those questions.
Please.
So the first question, do you think that the basic structure doctrine has made the Constitution rigid? As in, how much liberty do we have in deviating from those rigid set of rules? For instance, the same-sex marriages. Will we make amendments and provisions for the same?
So when we think about the basic structure doctrine, I think it's important to recognize what it does, right? There's a tendency to think of the basic structure doctrine as if it was some watertight straitjacket for the choices we make. It's not. The basic structure doctrine operates at a level of abstraction, which is it's a very high level of abstraction. So for example, the basic structure doctrine says that India is a democracy, and an amendment of the Constitution or an amendment or the passage of laws that damages or destroys the value of democracy will be struck down. Now, how many cases are there that would get struck down in this way by the basic structure doctrine. Very, very small number. So then you might ask, oh, this is an abstract doctrine, strikes down very few cases, then why do we have it at all? And for that, we must understand how the basic structure doctrine emerged. And it emerged in the period 1975, where there was a genuine concern that Indian democracy might wither away, like so many other countries in the developing world, that we will not survive as a post-colonial democracy. So the purpose of the doctrine is to really keep the constitution on the rails, right? Prevent a derailing of the constitutional form. And I think that's a vital function. The basic structure doctrine does it well. And I suspect that, that it's played a critical role in keeping Indian constitutional democracy alive. We tend to, and I'll say one more thing, though it was not in your question, we tend to view doctrines, legal doctrines and constitutions through political lenses, right? And either of the left or the right. Now, Indira Gandhi at the time in 1975 might have been seen as a sort of center-left leader, and she thought she was under a siege from the right of the Indian political spectrum. And then the basic structure doctrine operates and limits her power at that point in time. But when the Atal Bihari Vajpayee government formed the first NDA government, and they wanted to create a committee on the working of the constitution, and which many people saw as an attempt to work out of the current constitution in 1950, the insistence of their coalition partner, Chandrababu Naidu at that time, that the basic structure doctrine should be included in the terms of reference, ensured that those who were concerned that the politics of the right would derail the constitution, that did not happen, was not allowed to happen. So, doctrines, good constitutional doctrines are neutral to politics. And the basic structure doctrine has actually done that, right? It's controlled the extremes of politics on the left, as well as the extremes of politics on the right. And that is a good sign. And that's my sense. So it's doing its job. And I, for one, am a votary of that doctrine and the position that we adopt.
Thank you, sir. We have a question in the chat box. The delay of justice seems to be inherently ingrained into our system. Justice delay is justice denied, as the saying goes. Are we progressing on war footing to meet this challenge?
So it's a great question, and it's a question that many people ask, and for good reason. And I can answer that question squarely in some way, and then introduce some nuance to your question. The flat answer is no. The political executive, the political branches, both legislature and executive, are simply not investing enough resources and manpower to create an effective rule of law society. Why are they not doing that, you might ask? And I would say there's very poor incentive alignment for them to create an effective legal system. For starters, if they created an effective legal system, it would hinder executive and legislative power. Second, many of them are personally implicated in the legal system. If they invest in say, expanding and making our criminal courts extremely fast, many of them would be in trouble. So there's a misalignment in the political structure with respect to legal system reform. But it's fair to say that lawyers and judges have not acquitted themselves very well. The legal profession in India is a very different kind of legal profession. All of you in the IITs, you all know that you have to write some very competitive tests to get in, and then write some stringent exams to get out, and so on and so forth. But the legal profession is not quite like that. Pretty much anyone can get in and enroll for a law degree. It's not so difficult to get out on the other side. We don't have a very tough bar exam to get enrolled as an advocate. So it's a profession that's very democratic in some ways. It allows the widest social constituencies to get into the profession, which is a good thing. And I'm saying this with all nuance, that look, this is a good thing. It's good to have open professions, but we also have a difficulty that we don't have a profession that's always in tune with getting things done. They're very efficient profession. Judges are good at many things. They're not good at managing the court system, but they have a judicial role and they have an administrative role in the court system. And they simply haven't grasped the difficulty of that administrative role. Sorry, this is a long answer, but if you give me a short answer, if I had to give a short answer, I'd say legal system reform is not quite at the top of the agenda. It's not, and it's disappointing. I think that for a society like ours with such deep social hierarchies and such deep social inequalities, having a functioning legal system is critical. That is what will prevent the descent into violence. And we haven't got that. We haven't internalized that idea. There's time. We should do it now. But it's not, unfortunately, not on the top of the agenda yet.
Okay, thank you, sir. Another question. It is sad trend these days that it's observed frequently that something is written, a provision is there, however, it is twisted while those are implemented. If those are having some gap, do you think even tight and fine-tuned constitution can guarantee the safeguarding of something which is constitutionally provided? If not,
I listened to the question. I'm not sure what example the question might have in mind. Do you have an example, Ardha, that you can help me think through?
I think I think Shivatmika asked a question. If you can clear what exactly you intended, can you?
Please.
The question was asked by Anup, sir.
Yeah, I mean, I'm just trying to see what kind of problem it addresses, and that would be very helpful.
Can I talk directly?
Please go ahead.
Sure.
Yeah. So actually, in many cases, what we see that something is written in principle. This is provided. This is not. But while it is going to the implementation stage, that is not implemented. Rather, it is twisted some version. Okay. So if there is a gap, even something is there in the constitution that it should be provided to certain community or whatever. So is it the only last hope we have to approach always to the legal system for the safeguard, or what do you think that what's the best way to without going to the legal system is in any case is there at the last resort, but even not going to that, what is the law enforcing agencies, how we can make better accountable and like that. That is the basic.
So, thank you, Dr. Anu. As I listen to you asking the question, I'm tempted to take a slightly different route trying to answer it. And here is my attempt. Whenever we think about laws in a natural and physical laws sense, we tend to think about laws that operate as constraints on natural behavior or on the behavior of physical entities. And those laws operate unerringly and replicably to constrain those behaviors. So we have explanation when we talk about the laws of physics. We have explanations for the way physical phenomena occur, and to the extent that these laws are both accurate and analytically correct, they will show signs of consistency. When we think of social laws and law as in the sense that we're talking about now, we automatically understand that in social settings, all of these laws are going to be guided and shaped by human behavior. Now, it's human behavior, both individually and through institutions, collective institutions, that will determine outcomes. Now, the moment you put humans in, you know that humans will conduct themselves, will interpret and understand laws and apply them to concrete cases. Now, this core problem of moving from general rules to concrete cases cannot be escaped in any legal system. So we have the hermeneutic side to a legal system interpretation and application, or what you call implementation, simply will not go away. And we have to make our peace with that model of social control. There's no getting away from it. Having said that, there are more predictable human social systems and less predictable human social systems. And the challenge for us as a developing country is to move from what seem and appear to most common people as highly unpredictable human social systems to more predictable and formalized human social systems. That is the challenge before us. No, and I'll say one last point, and I'm sorry, I'm being slightly theoretical in this response, is why do human social systems become unpredictable? One kind of indeterminacy that we deal with is the indeterminacy of language. And I gave you an example earlier. Article 16.1 says equality of opportunity. Article 16.4 says adequate representation. The indeterminacy of those phrases mean that some humans coming down the line have to reconcile and apply those phrases together. So that's not going to go away, the indeterminacy of language. But the second big source of unpredictability is the willingness of human beings to allow extra legal normative factors. So, me as a person and my background, my education, my caste background, my being male, and my experiences growing up in this society will shape the way I think about the application of rules. So this extra legal variability, when coupled with the indeterminacy of language, allows for a great degree of variation, some of which is simply not justifiable. So the best we can do is to cut out the scope and applicability of these extra legal normativities. If we can, the indeterminacy of language we simply cannot get rid of. But if we get professionalized bureaucracies that are able to put legal system interests above their own personal interests and be dispassionate about their interpretation and application of the law, that's our best shot. Sorry for a slightly more theoretical explanation. I hope that's useful.
Thank you. Thank you.
Arthur, you are on mute.
Oh, sorry, sir.
Oh, you were on.
Yeah, sorry, sir. I'll repeat the question. Usually when we mention the word constitution, it's considered as a very boring documentary, when in fact it's important, very important to understand it. So what do you think is the best way to make people understand and read the constitution more often?
So, there are two kinds of constitutional documents. You have constitutional documents like the American Constitution, which is short and very crisp. And you can actually pick it up and read it in, I don't know, depending on your reading speed, you might read it in 2 hours, you might read it in 4 hours. The Indian Constitution is not like that. So I would not advise anybody to say that I'll just read the Constitution cover to cover. It is not a Talmudic or a Quranic or biblical text that can just be read by exegesis. You keep reading it again and again and somehow you'll understand it. It's not that kind of text. My approach, and the approach that I'm encouraging through this talk and elsewhere, is that it is best engaged through concrete problems. And those concrete problems are all around us. And I took an example, the Maratha Reservation. There are other issues. You may not be bothered about Maratha Reservation. Something else might bother you. You might be concerned about free speech. in which case, just digging a little deeper into what is that free speech case or problem that you're concerned about, how is the court approaching it? What is the history of the choices we made with respect to free speech? Why did we make these choices? These are the kinds of questions that I think will bring the Constitution alive. It is not a document that can be read after lunch. So we should not try to do that. We're much better off working with concrete problems, using the Constitution as a foil to think about these problems. That's what I would encourage.
Okay, thank you, sir. Next question. I think, so there are both kind of constitutions, written and unwritten form of constitution. So what do you think is a better one and why do you think so?
Yeah. So the constitutional form question, this written and unwrittenness is one of the areas of maximal kind of doubt and confusion. All constitutions are both written and unwritten. For example, in the Maratha reservation case, we dealt with the 50% rule. Now, if any of you ask this question, where did this 50% rule come from? Is it there in Article 16.1? No. Is it there in Article 16.4? No. Where did it come from? It came from a court decision. Now, how would I know? Just assume that I'm a young person, I'm born in the 90s, or born in 2005. I don't know how young all of you are, but maybe you're that young. And you have, you say, oh, it's not there in 16.1, 16.4, right? I can read the text. So the 50% rule is a part of our unwritten constitution. It's a part of the court's doctrine interpreting the text of the Constitution. So all constitutional cultures have an unwritten part and a written part. The only question is about the proportion. Some constitutions are more written, some constitutions are less written. The British Constitution is often put out as an example of a less written constitution. It's not like there are no written parts. There are written parts even to the British Constitution, but much of the Constitution is not captured in any text. So that's the way I would think about it. It's not a big line drawing distinction between constitutions.
Okay, thank you, sir. So we have a question in the chat box. If the one who has written it, if you can come forward and read out the question, that would be good.
Is it me? Should I read out the question?
Yeah, please.
Go ahead.
So basically, I just wanted to ask you that there has been a overreach of the judiciary in a lot of decision which the executive is supposed to have taken. In that aspect, somewhere I think it gives backdoor entry where the court is ruling, which technically should have been the decision of the executive or the bureaucrats. So is it a deliberate attempt, or is it is it the way of functioning of the Constitution per se?
It's a great question, and let me come at it from this angle. The first point is that the Constitution divides power between three branches of government, arguably a fourth branch as well. The three branches that we are commonly aware of is the legislature, the executive, and the judiciary. And the fourth branch is possibly the civil services and the independent institutions like the Election Commission and so on. Now, this division of power is not a division of power by subject matter, by which I mean, it's not like the government, the executive branch gets to decide on mining and the judiciary gets to have the last word on water resources and the legislature gets to have the last word on, let's say, historical sites. It is not a division by subject matter. It's a division by function. When you divide by function and say that the legislature legislates, the executive executes, and the judiciary adjudicates, it means that these are overlapping in subject matter. The moment you have overlapping jurisdictions over subject matter, it is bound to be the case that decisions are going to be taken in serial order. So the legislature might decide something, the executive might implement it in a particular way, the judiciary might disagree, and then that's not the end of the story, because then the legislature may get to change the rules, the executive may get to implement these changed rules, and the judiciary might get to have a second take on the question. So you might ask, why did we design a system like this? And the best explanation is not in the Indian constitutional history material, but it's in the American constitutional history material. And what James Madison in the Federalist Papers, which precedes the creation of the American Constitution, he argues is that the best guarantee of the freedom of the people, which is the point of the Constitution, is institutions that have overlapping jurisdictions that check each other. So what you might see as a defect in constitutional design for Madison is a deliberate design element. Slow down government, slow down the exercise of political power, the people will be free. So that's my response to the question. It's a very different response than what might have prompted the question.
Okay, thank you.
Thank you, sir. Next question. What's your opinion on the Constitution being the dead hand of the past, especially considering the representation in the Constitutional Assembly from marginal groups?
So the idea that constitutions must be continuously refreshed and that each generation must have a vote on the Constitution was an idea that was expressed by Alexander Hamilton in the drafting of the US Constitution. Hamilton suggested that constitutions should have a short life of 14 years. And every 14 years, the new generation, and that time they said 14 years, now we count a generation as roughly being about 30 years. So let's say 30 years in demographic terms, that a new generation should have the ability to vote on their constitution. Now that idea of constitutional longevity, short constitutions, is now no longer seen to be viable or desirable. Not even in the United States. So nobody backs Alexander Hamilton on his 14-year rule. Why? Why is the question? The reason is that there are two kinds of politics that we engage in everyday life. One kind of politics, and I'll just call it ordinary politics, everyday politics, is about how I can get a little bit of an inch more than you, and I can edge you out in small and big ways, and how I can get the political system to give me a little more than it might give somebody else. And generally speaking, this is everyday politics. Right? And everyday politics, it's not very principled, and it's about people jousting with each other to get maximal benefit. Now, constitutional politics, that is the politics that is not everyday politics that gets you constitutions, is very difficult to produce. Let's take the example of Afghanistan. You know, Afghanistan had the benefit of a lot of money. It had the benefit of a lot of experts. They wrote a constitution. They had US military presence for a very long time. And then as US military presence is waning, the entire constitutional system breaks down. This is not just an Afghan problem. Let's look at Nepal. Nepal is struggling as we speak. Anyone who reads the papers can see this, struggling to sustain its constitutional compact. It has the monarchy on the one hand, it has a fractious political culture. Ultimately, the constitution is not holding, it's not biting. Let's look around to Nepal, Sri Lanka. Sri Lanka is not having a great time with the constitution either. You have a Sinhala majority that had an overweening influence in the making of their constitution, and you have minorities, both Tamil and Muslim, who can't seem to get a way into this constitutional scheme. Right? So look around us in South Asia. What is the evidence we have? Pakistan, we know the story in Pakistan. There were 3 military coups. They can barely sustain a constitutional arrangement across 3 election cycles. So I think we have something special, you know, and this is my message to anyone who cares to listen. The fact that India remains a constitutional democracy 75 years after independence is an incredible political feat. It's a political achievement of the most remarkable sort, and one that we should be proud about. We are not so good with our economy. We have way too much poverty. We have way too much inequality. We are not so great with our social arrangements. Way too much social hierarchy and unfreedom in various ways. But we have done a fair job of maintaining a political system and a constitutional system. So I think that all said, the Constitution is of value in this sense. But you asked me a very specific question, Ardra, and I want to come back to that, which is the question of minority representation in constitution making. Now, if we were to take a proportional view, by which I mean that the proportion of people in the population are represented in the Constituent Assembly, the answer to your question is that clearly the Constituent Assembly was not representative enough. But if we created this proportional arrangement, whatever, different people might have different views about what proportion is correct, would we get a constitution of the same quality that we have now? I think that it's not a foregone conclusion for me, because of that distinction between ordinary politics and constitutional politics. There is something special about the period 1947 to 50 and the 90 years that went before that. It creates the conditions for a civilization to reconcile its various parts. Will that civilization reconcile its various parts again in a successful manner? I'm not so sure. All bets are off. The evidence are, even in our neighborhood in South Asia, is that we have done fairly well on the constitutional side, and we would do well to preserve it.
Thank you, sir. I will move to the last question. Article 370 took effect way back in 1954. It said that the states in India, except Jammu and Kashmir, accepted the Constitution of India as their own instead of having separate constitution. Why do you think Jammu and Kashmir was offered autonomy for deciding its constitution? Shouldn't the central government have had a say in the state government's ruling methods?
Yeah. So Article 370, I know that it's topical in the news, especially in the last few years, and with all such contemporary controversies, there are dime a dozen views on how this issue should be resolved. So let's take the historical view first. When V.P. Menon was traveling around the various princely states of India in a Fokker aircraft, trying to get the princely states to sign up to the Constitution of India, not all princely states came on board. Right? And what he did was that he signed these instruments of accession with the various princely states. Each instrument of accession is unique. Why? Because some princely's king wanted some additional palace. Then some wanted some forest to be kept to his family. Some wanted some control over a temple. And what did V.P. Menon do? Like a good politician, he signed different agreements with different people. Now, in our political culture today, Kashmir is made to stand out as if it was an exceptional case. And the communal dimensions of Kashmir, being a Muslim majority state, is one of the reasons why it has political salience today. In the 1950s, 47 to 50, we signed many agreements like this. Kashmir was not unique. So that's the historical. What should we concede and what should we not concede? And this is a point of historical judgment and something that we should think about. When we look at the United States and we see it as one of the strongest constitutional democracies of our time, we understand that the United States, the 50 states have 50 constitutions, right? They're not 50 states, they're 47 states. So there are 47 constitutions, and then you have these other three we call them states, they're not really states. They have different arrangements. Now, the fact that they have separate constitutions and the fact that they have separate federated arrangements, does it make the United States a weaker country, or does it make the United States a stronger country? Now, on general evidence, no country has seceded from the United States. They've added territory, they're not seceded territory. So I think there are lessons for us to learn, which is to ask the question, if we look at the end of, I won't be alive at the end of this century. Many of you will be alive in 2100. In 2100, what is this country going to look like? Is it going to have stronger provinces and stronger regional arrangements? Is that a good thing? I would say yes. It's a good thing. Does it mean that India will have secessionist forces? I don't think so. We can be a very strong constitutional democracy and one nation with arrangements and federalism that allow for people to have distinct identities. People talk today about Kashmir, but I think the state that all of you are residing in now, Tamil Nadu, was in the 1950s Nehru's greatest concern. He thought that Tamil Nadu was going to secede because of the demand for the recognition of the Tamil language and for the recognition of the distinct characteristics of Tamil political life. As we know now, Tamil Nadu is not seceded. It is one of the most prosperous states and one of the most efficiently governed states in the country. And I don't see how the assertion of Tamil nationalism has in any way damaged the Indian nation. These two ideas seem to coexist very well. And I think that a certain kind of political maturity at the 75th year of our independence can allow us to see that this will happen. This is all right. And we can create a very strong, prosperous nation, even with ideas like this. So let me stop there.
Thank you, sir. Thank you so very much for patiently answering all our questions. So it's time to conclude this wonderful event. On behalf of SECC and IIT Madras, I extend our sincere gratitude to Dr. Sudhir Krishnswamy for accepting our invitation and delivering an excellent talk to our students, and also for clearing all our doubts. I would also like to use this opportunity to thank our faculty advisor and all my dear friends who for your kind cooperation and support to the event, and hope it will continue always. Have an amazing day ahead. Thank you all once again.
Thank you, Ardra, and thank you, team. Bye-bye.
Thank you. Bye.
Thank you, sir.